Yes, my lord. Now, my lord, I say that.
So you want to append?
All right, the stand, let me put it
Yes.
to the standard, my lord. The standard is higher and let me, my lord,
And that standard you want to put in the first affidavit, but in the second affidavit, you don't want to do that. The second affidavit, you want said, whatever we are doing is right.
no, my lord, if that's not the position.
No,
my lord,
it is there on your stand.
my lord, so
We
therefore,
cannot go more than this.
so therefore, my lord,
Mr. Maninder, probably nothing is there in this argument.
no, all right, my lord, I am going.
Nothing is there in this argument. Please.
No, my lord, I am only saying
Yes.
that the.
You are saying that the discretion is vested with you under this clause, and in exercise of that discretion, if you made a concession pro advocate general before the High Court, and if it is regarded by way of legislature subsequently, and examination have been conducted accordingly, then it cannot be put into hold by this court.
And
This is your
with
contention.
one more.
Full and final.
I'm deeply obliged.
Anything else?
One more submission, my lord, that a expansion of the consideration zone, any attempt.
Is permissible.
My lord, it is justified and it is, this is within the scheme of the constitution to give opportunity.
Oh, those.
My lord, my lord,
Along with that, there is another,
Yes.
one
preemption.
more submission, my lord.
what your rules says for recruitment. These guidelines will not take away the rules. The
JTET,
statutory rules framed by you for recruitment of teachers.
JTET.
309.
Yes, my lord.
So how those will be taken care of
Rule them are amended.
later on?
No.
For that, they have a different argument.
I'm coming to that argument. also.
Yes, yes.
Yes, so therefore, the rules before the last date of the application,
All right, that argument is a separate argument.
I'm coming to that,
But this will not take over everything till such time the rules to the contrary are there.
No, my lord, therefore, my submission is this. My rules for this election also provide CTET also to be permissible.
After amendment.
From January 24,
Yes.
29 January 24
Yes.
after the amendment.
Yes.
After
Last
one thing
day.
is, after this judgment, in reference to the judgment, rule have been amended. And the judgment is under challenge before us.
Lord, I will show your lordships a similar situation where your lordships have permitted that with reference.
All right,
No, my lord, with
all right.
reference.
So we have to be very clear and specific on the point
My lord, your
that how
lordship.
far the judgment is correct.
Yeah, Lord, let
If
me.
the judgment is correct, then there may be a possibility your argument may be acceptable. But if the judgment we find not correct, then
I'm coming back to that. So, my lord, my first submission, your lordship saw the July order. The July order of 2023, which your lordships have seen at page 52, my lord, in the counter affidavit, the interim order, this only gives an observation for suggestion for the state to consider. And that consideration is that there are people who are we seated, they are already available, they are now coming before us that we should be permitted. Why should we be blocked in sitting in the TET, in the entrance examination for this recruitment? You please consider it. This has been considered, my lord, and at the time when the matter is finally argued on the file, whatever decision they have taken, the learned advocate general is instructed to make that submission. The judgment only records the statement made on behalf of the state for its policy decision. That policy decision, my lord, in my respectful submission, even if it would have not taken, it had now taken the character of an amendment.
Mr. Maninder Singh, I'm sorry to say, any statement made by the Advocate General cannot be said to be a policy decision of the state.
Statement.
If it is being just, please, no.
But I'll show to you.
No, sorry. If it is being said by the Advocate General, now the state government has taken a policy decision, and by that policy decision, we are going to that, we can understand. And the state government, if the Advocate Generals gave a consent, no, please, we'll do it, and that cannot be said to be a policy decision. Sorry to object for it.
These are the.
No, Mr. Maninder Singh, we cannot accept like this. After your stand taken here in this case, like this, an Advocate General gives a concession. It's a concession only. Cannot be said to be a policy decision. You read the words. Kindly read the words in the judgment.
I'm only looking at.
No, sorry, Mr. Maninder
Looking
Singh.
at
No,
that
sorry.
My lord,
Please, we can understand whatever the words. You kindly see the wordings of the judgment.
yes, my lord.
Kindly see the wordings of the judgment.
There are 6 at page 11.
However,
In course of hearing, these are today, learned advocate general appearing for the state would submit that he has received oral instruction that the state is willing to relax the criteria.
Criteria.
It's a, now this is a policy decision.
No, no, no.
Well, that's
This
why,
cannot be said.
my lord, if the
Sorry.
state considers it, my lord, state considers it
Yes.
and, my lord, state considers it, inform the learned advocate general that you please inform the honorable court that a
Let
disorder.
him say that's a policy decision has been taken by the state government and we are doing this.
The
Let him
state-
say.
The state is willing to relax the criteria for eligibility as far as the candidate having CTET examination
Sorry.
certificate with a stipulation that in future date they would require.
Come to your argument,
qualify.
please.
So that's my lord, that's my respectful submission. This policy decision then
No,
gets.
no, no.
My lord,
You can take a policy decision contrary to the rules.
my lord, if the rules have to be amended, the policy decision is taken always.
Framing of rules is matter of policy.
My lord, the
Said
rules,
policy have been, framed.
amendment
rules have been
of the
framed in
rules.
309.
my lord, the amend, yes, my lord, the
This we
amendment.
cannot accept. Otherwise, every day the state can do. The
Well, it is-
sovereignty and sovereign powers of the states are not prescribed
My lord, yeah, my lord, that's what I'm,
for this purpose.
my lord, that's why I'm.
Sorry,
And just see whether there is any power of
Go ahead.
relaxation given in the statutory rules for recruitment.
My lord, if supposing, my lord, if I go by the clause 10 of the guidelines,
Guidelines will not supersede the rules.
I'm not saying, my lord, I'm saying my rules amendment is to come in guideline with the NCT and take the CSTAT in.
That's all.
My only respectful
All right,
submission.
that is a separate argument. We'll consider whether for after amendment, your cutoff date will be
Yes.
seen to be a good action.
So my first respectful submission go at this stage, my lord, only at the cost
and
of.
therefore with this intent, we have put that Bihar case separately. Understanding this,
Challenge to the
argument.
virus.
Yes, my
We have
lord.
said we will hear that.
Lordship is
case.
right, absolutely right. So, my lord, therefore,
In that case, the situation would be different.
my lord, therefore.
Because in that case, we have to look into the regions, statement of regions and objects, what was the region in that.
Yes, my lord.
That is entirely a different thing when we are examining the case of the varies of. Anyway,
Now,
you
therefore,
carry on with your
proceed now.
argument. Yeah,
I will,
proceed.
my lord, I would seek a lordship permission when I am arguing the next point, that you can't
To
change.
come on the next point, we have
I'm
understand your point. We have already clarified you. We have understand your point.
Yes, my
You
lord.
please come on the next point.
Now, my
Please,
next,
Mr. Maninder.
yes, my lord. My next submission is, my lord,
Yes, please.
that the amendment having been made in January 24. Now, my lord,
Which
here,
is that amendment?
29 January.
yes, my lord, that has been
Which
placed
page?
from the court,
This
The
is
counter
in the
is
counter affidavit.
out of it.
Yes, my lord, page 60,
60.
Yeah,
page 60.
29 January.
29th of January 24. Under powers conferred to proviso to Article 309
Hmm.
of the Constitution, the Governor of Jharkhand hereby makes the following amendments in the assistant teacher cadre appointment so-and-so rules of 2023, which is allowed originally 22 and 23 were also amended. From following amendments are there, the rule made under the clause A. The rule shall be called so-and-so amendment rules of 2024.
Hmm.
And then, my lord, for the present purposes, your lordship will see page 63, clause 6 and clause 7, the middle portion and the latter part. Well, but in subclause capital B of 6.
Hmm.
Which is for class
Subclause.
1 to 5, my lord.
Serial number.
The para is with the in addition to the above, my lord, which has been added by the amendment.
Where is that?
My lord, at page 63.
Oh, 63. Yes.
So sorry, my lord, 63, clause 6. Then, my lord, capital Roman B.
Hmm.
And after that, your lordship is qualified in teachers eligibility test in JTET, my lord, which is the original provision. And this in addition to the above.
Hmm.
This has been added, my lord, in the rule. I'll just permit to read this, my lord. Such residents of the state of Jharkhand. Lord, that's it, Bindal has got.
Yes, yes, we have.
My lord, 63 in that subclause capital B.
Hmm.
The first para is the original provision. Amendment is, my lord, in addition to the above.
Hmm.
In addition to the above, such residents of state of Jharkhand who have qualified in the central teacher eligibility test conducted for class 1 to 5 under the guiding principles formulated by the NCET or qualified in the teacher's eligibility test conducted by the neighboring states of Jharkhand are included in the appointment procedure on the post of assistant teacher subject to this condition shall be mandatory for them to qualify JTET in a chance available within and 3 years after the appointment. And with regard to, my lord, the higher position, kindly see 7.
That is for higher classes.
For, my lord, see
1 to 5 and 6 to 8,
yes, my
basically.
lord. Same, my lord, for.
But what is
Same in
the,
addition.
what is the definition of neighboring state?
My lord, that's, there is no separate definition given.
Then how do you define it?
But like Bihar would be the neighboring state, my lord, from where they have
So a
emanated.
matter of choice, anybody can say Nepal also is we consider our state.
Have you put in some states?
It's not vague then.
But yeah, any, my lord, of course, my lord, your lordship is right, that whether any guiding principle is there which is to be taken.
These are the rules.
Yes, my lord, I'm saying so. I'm agree, my lord, I bow down to your lordship's observation.
And these will have to vague like this.
There's no definition, my lord, which has been given. So this has been left, so this, boundaries. In the neighbor, the, my lord, boundaries, so my lord, maybe that is the only possible explanation which I can give.
Jharkhand, Bihar,
Bihar,
Bengal.
Bihar, Jharkhand, we can understand.
Yes.
Jharkhand
Come
with
then attaching with the Orissa, attaching with the
Odisha is
Andhra
not
Pradesh,
connected.
attaching with the West Bengal,
Jharkhand.
Alangai. They don't know the language even of local. Can we take into a neighboring state? Then you see the Bihar, then these are the state connecting Uttar Pradesh at first side. The another state comes to that West Bengal, another state comes to Orissa, third state come to Andhra Pradesh.
Yes, my lord.
Can their languages can be,
कितनी हैं?
on saying the officer, it would not be neighboring state.
Plan दिखाना इसका.
On saying your officer, it would not be neighboring state.
India का नक्शा दिखाओ इसका. India का नक्शा.
The officer would keep something in your mind, keep him in his mind. We are not concerned with that.
My lord, the Bihar is there, West Bengal is there, Odisha, and my lord, Chhattisgarh.
That is,
Yes. These are the 4 states which are, and my lord, there the languages I'm told are the common, my lord, in these states. Maybe
how you can say so?
some different.
How is
So
it
that
that
would-
Orissa? How? Nobody, you go there and nobody speaks.
My lord, on the borders, my lord,
No, nobody speaks even.
Question of border.
You go in West
borders,
Bengal,
the
nobody
languages
speaks.
are overlapping, my lord, your lordship. Sir.
No, no, no.
Yes, yes, my lord, the borders are between.
Border may be borders,
Cannot be, sir.
border districts only.
But Karnataka and Maharashtra, there are on borders area, they speak, my lord, both the languages.
That's all right, but only the
It's
people
not
living
sticks.
on the border.
Neighboring state.
Yes, my lord.
Mr.
So-
Next, please go
You
in.
have connection with Uttar
Now,
Pradesh.
anyway, we have understand your, in addition, you have what the use. Now, you want to say, and now because this is an amendment made
Correct.
prior to starting the selection process, though even after the advertisement.
Yes, my lord.
So that may be taken note of for the purpose of process of selection.
Yes.
You want to say this?
Yes, my lord.
And show the judgment.
Yes, my lord. Two submissions.
Come on the judgments.
I'll show to your lordship. My lord. Two submissions which I wish to make, my lord.
Yes.
That the last date which is fixed in any advertisement, if there is no statutory stipulation for that in any statutory rule or the act, and for any justifiable reason, my lord, the date can be extended, that date becomes the cutoff date for the purposes of that advertisement. My lord, I've got 2-3 judgments.
No, no, where is that extension?
I'll show that, my lord, there are
Not
extensions.
there.
What is the
Yes,
last
yes.
date in extension?
Yes, the last date extension which, my lord, I have and I want to hand over, my lord,
Not handover, there is nothing on record.
There must be publication of it.
yes, yes, they are publication. They are
Please
publication.
show this
Yes.
which is shown to us.
That was only for
You please show
differently able
the
people.
document which they have shown.
But
the
I just give
advertisement.
you the list of dates, so your lordship, what my learned friend.
Not
has-
No,
list
list
of
of, we are,
dates will
we
I
are
will
concerned.
not have only show it from the
Mr.
record,
Marinder,
only for.
please
cleaning.
come to the document of that.
My lord, I will.
Here, there must be a document, not
Yes,
something.
yes, my lord.
Show the document
Yes.
from here.
Yes, my lord. The original notification is 19th of July 2023,
Page number,
which is 260. The advertisement is not on record. The-
Advertisement is on record.
If-
advertisement is on record.
Extension is not on record. What they have placed on record is only for differently abled people.
My lord,
No, no,
it-
both are there. Inviting application
It is for
as
both.
well as both are there on record.
Post-
Page number,
Postponement of test
वो कौन सी
and extension of date.
Yes, my lord.
Page number, madam?
257. Yes.
Permission to place additional documents on record.
267 in the additional documents, my lord.
267 and 268.
Yes, my
267 is
lordship
the
right.
10/1/24.
Yes, my lord.
In
10
compliance of so and so
Yes, my lord.
passed by the Jharkhand judgment. High Court of Jharkhand, so and so, so and so, so and so,
You get it, man?
local resident of Jharkhand state who have passed CTET and TET from neighboring state,
And
willing
for
to appear in the
so and
Jharkhand
so,
primary school, so and so.
Online application for the above examination are invited. For inviting application from the above mentioned types of persons is being activated soon on the website of the commission. Also, in the light of the above, rescheduling of the examination scheduled of the Jharkhand Elementary School Trained Assistant Teacher 223 is to be held from 1/1/24 is necessary.
12/1/24.
12/1/24 is necessary, and the above examination will now probably will be held on 10th of
But this is not extension of last date. It's only exam, intimation for exam.
because there is no date fixed for last date. Is the
They
exact.
can't be.
My lord, that's what
And I
you.
put it in a different way.
Yes, my lord.
If we see this notification,
Yes, my lord.
then this notification only indicate because there is a judgment of the Jharkhand High Court. And in lieu of the judgment of the Jharkhand High Court, we are inviting the applications from those persons
Correct.
who are having CTET. And because of inviting the applications from them, we are postponing the date of examination on 12/1/20 to 12/1/24 to 10/2/24.
Absolutely.
It is nothing more.
Because 29.
So it is not the advertisement or extension. It is just a compliance of the order of the High Court.
May I respond?
We can understand.
This, what is the date of this? 10th January.
In January.
And amendment is 29th
29th
January.
January.
So it is not in persons
So
to that.
amendment of 29 January when it takes place, there is a notification thereafter.
Show us the date extension
I'll
notification
show
for
you
last
the-
date, cutoff date.
My lord, the cutoff date has been then changed. My lord,
Show us that.
Yeah, 22nd of March 24.
Where is that?
My lord, 22nd of March, the corresponding changes in the recruitment rules were also made, which were made in the notification, which I informed to your lordship. And therefore, the revised date of submission was, my lord, from 6/23/3/24 to 6/4/24, and the last date became 6/4/24. Just 1 second, my lord. 28 है 6/4/24. दे दीजिए उधर भी दे दीजिए. Lord, the gadget notification copy, if your lordship may permit me, because they are all aware of this notification.
All are aware of, but nobody has placed on record. You are not aware of?
I should have. It was my duty to place it on record. The registration is, my lord, from 23/3/24 to 6/4/24. Then payment is 8/4/24. Photo and a sakshar upload is 10/4/24. Online application is 11/4/24 to 12/4/24. And then, my lord, the exam date was fixed from 27th of April to June 2024, because there are various some kinds of exams which are to be conducted, and examination has been held. And, my lord, before 10th of January also, my lord, there was another order in another writ petition before the Honorable High Court, where the process during August to September had remained stayed, and subsequently the stay was vacated. And then this proceeding in this writ petition has started, which culminated into the July order first and then final judgment in on 20th of December 2023, which was followed 29th of January 24. My lord, the amendment was made. Then amendment in the corresponding rules is made on 23rd of March 2024. And then, my lord, the last date was in April 24 for the application. And, my lord, the examination is held. And, my lord, which examination, etc., they challenge, which, my lord, your lordship in the other SLP have been rejected on 9th of September 24.
Under SLP.
Yeah, my lord, there one more which I informed in the morning, your lordship, that that's a different way. My lord, rules of 2022, the present.
That is entirely different.
I'm only saying that
Other SLP.
that was decided on.
That was on a different point.
Yes, my lord, that they challenge the validity of 22 rules and then the advertisement, but your lordship may just keep it aside. Now, my lord, two judgments for your lordship on this. I'll make my submission. My lord, in similar circumstances, my lord, two judgments, my lord, if your lordship may permit me, I want to first of all read of only few portion in 2017.
कागज घर जाते हैं तो निकल जाते हैं जब हमारे पास पहुंचता है तो फाइल ही नहीं पहुंचती मेरी फाइल की वोटिंग दूसरी पहुंचती है फाइल दूसरी पहुंचती है ये नहीं होना चाहिए
खत्म कर देना पड़ना 2017 1 SCC 350
One SCC,
2017 1 SCC page 350
which paragraph?
because my lord, para your lordship may note, my lord,
2017 3
2017 1 SCC page 350 paragraphs, my lord, which I wish to rely upon 6, 7, 8, 13, 14 and 17 and thereafter 39 to 47.
On which issue?
On this very, my lord, TET issue, where, my lord, in terms of clause 9, the relaxation was made by the state, and it was questioned that you can't make it, only central government could have done. And that, my lord, your lordship said that in
That issue is not there.
my lord, I'm saying clause
We
10,
are all governed by the statutory rules.
my lord, here
It's
also,
not simply relaxation will help you.
no, my lord, kindly permit me to say this.
Even if you take a decision under clause 10,
Yes, my lord,
it has to be still transported in the statutory rules.
it has been,
So main argument is that whether that amendment applies or not.
my lord, that's what I'm respectfully.
In the absence of amendment, you can't take benefit
So
of
the
that.
amendment of 29 January.
And for that also, there is no decision. It's only the statement of the AG in the court. That's all.
Let us, my lord, your lordships have considered that order of 20th of
Yes.
December. My respectful submission is that has transported into a amendment in the statutory.
We have to see whether that amended rules,
Yes, my lord.
after which you extended the date also, will apply or not apply.
Yes, my lord. So I'm saying, my
So
lord.
this relaxation judgment may not
No,
help you.
my lord, this relaxation only says that it is within the domain of the state as well as that it related directly to the guidelines of the guidelines of NCTE. Kindly have a look at that, my lord. I will not take my time, my lord, in these two judgments because the second judgment also takes care of the decision taken by the state and, my lord, the arguments that you
prior
have.
to going to this judgment is completely based on this guideline 9
Correct, was same guideline 9.
same guideline 9.
Yes, which I pointed out to your lordship when I was reading the guideline.
All right.
Yes, my lord.
Same guideline 9 if we look into, then what is the guideline 9 and how it would apply here in this case?
Yes, my lord. My submission is, my lord.
No submission, please, we will read this 9 also, then we'll go by that.
Very well, my lord, your lord. Kindly come to guideline number 9.
Scores 60% or more in the TET exam
Yes,
will be considered as TET pass school management, government, local bodies of schools. May consider giving concession to a person belonging to so and so should be weightage to the TET score recruitment process of so and so.
so, my lord, the argument raised was that.
How this
Yes,
can be
I'm-
very material
Yes, my lord.
to this applicability of that provisions of the RTE Act.
Yes, my lord. Now, my lord, the argument raised was that this concession could only be under 23(2) by the central government, so it could not have done it. And your lordship said, no, sorry, it is the discretion freedom granted by that guideline itself.
That's all right, Mr. Maninder Singh. We have said that even if you take a decision in clause 10,
Yes, my lord.
because statutory rules are there,
Yes,
unless those are amended, This decision is useless.
No, my lord,
Then you said 29 January, you amended the rules.
correct.
Now the position boils down is that whether those rules are applicable for this recruitment.
That exactly I'm trying to
So
show.
this is not relevant.
My lord, this judgment is only to that effect, my lord, that if the discretion is left with by the NCT itself in the guideline to the
No,
state government.
it is not like that, please, Mr. Maninder Singh. I am adding the query. If we see 23(2),
Yes, my lord.
in the 23(2) does not say whatever you want to say, it further says qualifications. And the qualifications have been prescribed by the rules. Once this qualification have been prescribed by the rules, then the question, if it is amended subsequently, then what would be the effect of it?
Yes,
This is the question.
correct, my lord.
So
No,
we
but-
are adding this part.
Therefore, my lord, while keeping those question, my lord, and with the addition, I want to read few paragraphs of this judgment. I will not read it, my lord, and skip it if
This
there's.
judgment is not
My lord,
applicable at all,
Kindly see
to
the
my mind.
my lord, your
It's
lordship.
not at all applicable.
My lord, if your lordship may kindly see that this particular analogy which is taken, that the center state had no power to do it.
Analogy, we have to look into what the question we are posing
Yes,
to
my
you.
lord, if your lordship may.
32(2) also added a qualification. Once it is added with a qualification specified in the rules,
Yes,
how this can be added?
yeah, let us. see.
Sorry?
My lord, kindly.
And that rules are there of 309
Yes,
at
my
that
lord.
time.
My lord, my lord, this, I need not, my lord, trouble your lordship by repeated submission that as, my lord, this is.
All right, we'll consider this para. Next, go ahead.
1 second, my lord, 20, my lord, the.
Mr. Maninder Singh, if something is applicable, not necessarily that everything has to be heard.
Yes, my lord.
Which is not at all relevant
Not
for
at
our
all, my
mind.
lord, that I'm not insisting for.
Sorry,
Which
please.
may not be relevant.
Sorry, we can understand. We can understand.
Yes, my lord.
What is the relevant point for us?
My lord, if your lordship may just make a note of para 38.2. Where this question was, issues were framed in para 38. And my lord, from 39 to 47, your lordship may kindly consider. I will not read any provision, my lord. My respectful submission is this much, my lord, that the same argument which was taken, that it was for the central government to exercise that jurisdiction, state couldn't have done it, has been specifically rejected. Now, my lord, second judgment is 2017 1 SCC 322. Here, my lord, in my respectful submission, in my reading, any subsequent change after the issuance of the advertisement and the application that been made, which was brought into the, my lord, exercise of the recruitment process, all argument that this could not have been done, and they are all after the issuance of notification cutoff date have been rejected one by one. Kindly come to, my lord, this judgment. And if your lordship want me to, my lord, give the para numbers first. I can give that, otherwise I'll just run through it, my lord. My lord, there were,
This is the two judge bench.
yes, my lord.
And we have three judge bench judgment.
In against this, my lord.
22
judgment.
judgment they have said.
No,
2020.
I'm on this point, on those 2 points, my lord, that you
If
can.
we would like to see that.
Yes, my lord, kindly,
Would
see-
like to see that.
kindly see that, my lord.
Which paras?
Yes, my lord. My lord, first of all, your lordship may kindly come to para 1. Where, my lord, the court has noticed that on the same issue, there are two different views, one by the Madras High Court and the other by Madurai bench. And the matter came before your lordships. Then, my lord, your lordship may kindly see the reference to that communication and guideline, my lord, of the NCT in para 2. Kindly come to 3. The original government order, my lord, for starting the recruitment process is mentioned between placetum D and E in para 3.
We don't have plus.
We don't have placidums.
Because that's the soft copy only.
We only have a soft copy. Either you give it.
Para 3, my lord.
Para 3 is not like this. In pursuance to the provisions of the.
I'm reading that para.
Hmm.
In pursuance of the provisions of the Act, the state government enacted the Tamil Nadu right so and so. State government issued order number so and so prescribing 60% marks, my lord, which is given there. The teacher recruitment board was appointed as agency for conducting the TT and recruitment of teachers. State government wide a GOM of 252 issued on 5/10/12, my lord, just mark it. So the recruitment process started with this government decision, which is, my lord, dated 5/10/2012. Then, my lord, your lordship will see the result which came out, which is put it in the table, my lord, that this was the pass percentage, etc. On the basis, my lord, the say,
No,
recruitment-
you're wrong, you're wrong.
I'm sorry, my lord.
Just see, subsequently, the state government, via GOM so and so dated 5/10/12,
Issued the-
issued the procedure
Guidelines
guidelines for
state.
state, that's all, not recruitment.
I'm going to show.
Ah,
The said guidelines earmark 60% for the state eligibility test
Right,
and
right,
40% for your academic performance.
Right, right.
That was the original criteria which is fixed. Now, my lord, on that basis, the result which came out is quoted in para 4. It is put in the table. Similarly, my lord, para 5. Kindly see last 4 lines, because second TET is taken, even then the result was not so good. The third TET was taken, which is recorded in para 5, and kindly come to last 4 lines. In January 2014, because the criteria is fixed, my lord, which your lordships have seen in the OM of 60% and 40%. In January 2014,
when the advertisement was issued.
my lord, the advertisement is after 2012. The
Date is not coming.
But my lord, this is before this. I'll show it to your lordship.
All right.
The last 4 lines, in January 14, candidates who had obtained 60% or more were called for certificate verification.
That is mentioned.
So this is not pursuant to that advertisement that the process was laid down. The who had obtained 60% or more were called for certificate verification. Verification was done in the GOM of 5/10/2012, and weighted marks were also awarded. However, recruitment of teachers and appointment thereof was not done. So the process had already begun. This was the criteria fixed, and the criteria, my lord, now is changed. If your lordship may kindly see para 6. A government order is passed, my lord, which is, my lord, government order number 25, which is issued in 2014. By this, 60% was made to 55%. 60% was NCT, state decided to reduce it to 55%. Now, my lord, in this, the decision which is taken is 6/2/14, which is quoted, that GOM 25. It is quoted in that paragraph.
But you had rightly said the higher standard of this CET you want.
I'm coming to that, and then I'm trying to answer your lordship's other 2 queries.
No, this is answered here.
No, my lord. I'm
Not answered.
No, my lord, it is answered.
CET said 60%, you say 55.
55%.
Actually, there has standard is higher.
That is why where the discretion and the play in the joint which is made available to the state government. Now, my lord, kindly come to this, just 2 lines above para 7 on the next page. The said relaxation was held applicable to TET held on 17/8/13 and 18/8/13 and all future CETs. Then GO number 29 was, my lord, made on 14/2/24, which is, my lord, now changing the criteria which was originally fixed for this recruitment. And this, my lord, gave rise for filing of writ petition, which is in para 8. And if some of the writ petitions, my lord, were rejected, upholding the GOM of 25 of 2014, 6/2/14.
That's a different thing.
Now, my lord, just 1 second. However, the learned single judge, then there was an issue of grading system, your lordship may skip. Then, my lord, in para 9, pursuant to the order passed by the learned single judge, while continuing with the weightage of so and so as per the GOM 252 scheme education department 5/10/12, with reference to the basic qualification mark, the state government passed a subsequent order of 71 school education department dated 30th of May 14, in tune with the suggestion made by the learned single judge. So, my lord, there also the High Court suggested something. And, my lord, the government order is issued in a process which has begun in 2012. The suggestions are made in 2014. Next para, my lord. Pursuant to the order passed by the learned single judge, etc., and that, my lord, kindly see quoted para 7 in that para 9. The government now received revised order for fixing the weightage and the distribution of weightage of mark fixed in the light of the High Court order. Then, your lordship may kindly come to para 10. So, Madras High Court took a view that this modification is valid, which is made in 2014. But please see what the Madurai bench has done in para 10. The High Court of Judicature, Madras, heard various writ petition filed before challenging GOs concerned, and by the order impugned herein disposed of the same. The High Court dismissed the writ appeal as well as the writ holding that the challenge to the policy decision of the government. So, my lord, foundation is a suggestion by the High Court. Government takes a decision to relax, and that, my lord, has been issued through a GOM. And then, my lord, the High Court considers that and, my lord, accepts the changes made and the writs are dismissed. Now,
Let's come further now, this
Madhuri bench
discrepancy
is
is-
para 11.
That's all right.
Now, my lord,
Come to
we,
the substance.
yes, my lord, if your lordship may kindly come to last 3 lines of para 13.
Yes.
It was submitted that the government had reduced the passing percentage for qualifying in TET and changed the criteria. Please mark it, my lord, last 5 lines of para 12. My lord, if your lordship may kindly see with me. It was submitted that the government had reduced the passing percentage for qualifying in TET and changed the criteria for selection after the commencement of the selection process, which is arbitrary, illegal and violative of Article 14. Reliance was placed on K. Manjushri and Emani. High Court contended it's impermissible to change the rules of selection once the selection process has started. Then, my lord, your lordship considered this. The state contention is recorded in para 13. Permit me to read that. Per contra, the learned counsel appearing for the state submitted that the relaxation has been given by the state only to reserved category. It was submitted clause 9 of the NCT guidelines empower the state government to give.
What are the questions framed? Let us see.
Yes, my lord, your lordship will see the
Question.
question in 14.
Para 40.
14, my lord, just before that, in the 4th line, my lord, your lordship will see on the top, 4th line. TET qualification, TET examination is a qualifying examination.
That's all right.
And
We have to
14.
see what are the issues
Yes.
considered by this
Yes,
court.
my lord, 14.
Ah,
Kindly see 14.1, 14.1. Whether the state government has the competence to give relaxation of 5%.
This is not relevant for this case.
My lord, this is what
No, it's not question of,
60% is fixed.
issue is whether the amendment carried out later on is
I'm showing that,
applicable.
my lord.
Read that question.
My lord, kindly see the first question.
First will not fall in that.
My lord, first question is that the state,
Please go ahead. Come to the next question. This is only with respect to grant of relaxation.
Yes.
This has nothing to do. Please go ahead.
my lord,
Next.
the relaxation, just
Please
permit-
go ahead.
my lord, relaxation of 5%, which is given is to the stipulation of NCTE that minimum would be 60%. That relaxation has been given by the state government. State government did it, my lord, from a suggestion falling from the Honorable High Court's order. And then that is carried out by issuance of the amendment order, my lord, which was issued. That was put in question that this is a change after the process has begun. In that behalf, my lord, first question which is framed is whether the state could do it. That is the first question, my lord. Your lordship may just make a note and kindly come to para 16. I'm not reading it, my lord. Your lordship may just make a note of last 3 lines of para 16. Then 17, my lord, reference is made to section 23. Then kindly come to 18. Same argument, my lord, 18, that this relaxation could have been done only by the central government and not the state. State was not empowered, my lord. Just make a note of 18 if your lordship permit me to read it. Otherwise, 18 is the contention, my lord, which is paramateria to the contention which was raised in the opening year. Then your lordship may kindly come to 19. The contention on behalf of the state. The respondent state has maintained that the government was well within its power to take a policy decision of granting relaxation to the reserved category candidate. In this regard, the state has placed reliance on clause 9 of the NCT guidelines, my lord. And then if your lordship may kindly come to straight away the relevant portions. The judgment, my lord, which I cited is quoted in para 25. And then, my lord, just come to para 28, 30, 31 and 32. Para 28.
28.
Yes, my lord. We are unable to persuade ourselves to accept the view of the Madurai bench quashing the impugned GO on the ground of alleged change in the stand of the government. Considering the representation from various quarters, it was a policy decision taken by the government to relax marks of TET pass for specified and underprivileged communities. It is a matter of state policy to frame and prescribe selection norm with regard to service and posts connected with the affairs of the state. It is well settled that courts cannot interfere with the policy decision of the state, especially when the policy decision is taken in public interest to further the advancement of reserved category. Policy decision, then your lordship may skip. Kindly come to para 30. The appellants have contended that the provisionally selected candidates were called to attend certificate verification on 23rd January 14 and 24th January 14. And weighted marks were also awarded as per the existing government order. While by issuing impugned GM number 25 dated 6/2/14 and GM 29 of 14/2/14, the criteria of selection was altered by relaxing passing mark by 5% in TET from 60% to 55%, therefore allowing large number of candidates who scored lesser marks to be considered for selection. As per the appellant, this has resulted in altering the criteria of selection and after the commencement of the selection process, two earlier judgments are referred to. Kindly come to para 32. The appellants appeared in TET. Well, 31 is the stand of the state. Kindly come to 32. The appellant appeared in TET conducted on 17/8/13 and 18/8/13. The respondent were to select the suitable candidate as per the selection criteria laid down in 252, which was 2012. The candidates have to secure minimum 60 in TET so as to qualify the said exam. The weightage of marks secured in TET was 60% and that of academic qualification was 44%. It is true that candidates who passed in TET were called to attend certificate verification on 23/1/14 and 24/1/14, but the selection process has not been completed. Later on, GM number 25 dated 6/2/24 was issued, granting relaxation of 5% to SC/ST backward classes, physically handicapped, denotified communities, etc. The purpose of relaxation was, please mark that sentence, was to increase the participation of candidates belonging to so-and-so pool teacher. State government merely widened the ambit of TET so as to reach out to those candidates belonging to the deprived section of the society who were not able to compete in spite of going ahead academic records and qualification. The change brought about to the selection criteria is the government prerogative. In terms of the extant reservation policy, the state government is free to take action suitable to suit economic.
Probably after reading this part, it necessary to ask any question. Why this was there, what was the situation,
But the
and in the which situation this was judgment. It necessary to ask any question. Mr. You know, Mr. Manager.
No, my lord, without, no, not on this.
That is all fine.
My lord, with utmost.
Go ahead, please.
My lord, kindly note, just permit me to read para 33, 34 and 30.
We have permitted all these paras.
Yes, one, two paragraph, 34, 34.
No problem.
The government, kindly see, my lord, 34. The government are not changed the rules of selection so far as the present appellants are concerned. Weightage of marks obtained in.
Because they may be of general category.
I'm sorry, my lord.
They may be of general category.
Yes, my lord, they, no.
That's why for them it was not changed. It was changed for a different section of society.
But that, my lord, is a change to the existing norms which were notified as.
Only for that section. That's why the court used the word. It is not changed qua the petition.
But it is challenged on the ground that.
That's all right.
I'm only on that ground, my lord, that you could not have changed after the process has begun.
All right.
I'm only to that to satisfy your lordship, my lord, from that perspective. Now, just two more paragraphs, not 34 and 35.
Yes.
The government has not changed the rules of selection. The entire selection process conforms to the equitable standard laid down by the state government in line with the principle enshrined in the constitution. It is not the case where basic eligibility criteria has been altered in the midst of the selection process. Conducting TET and calling certificate verification thereafter is an exercise which the state government is obliged to consider every year as per the guidelines. Then skip 2-3 lines, my lord. No prejudice has been caused to the appellant since the marks obtained by the appellant and TET are remain valid for a period of 7 years. Now, my lord, here also it was 7 years. Now it has in Jharkhand, I'm instructed to say it, my lord, it is once you have to pass and then it.
Otherwise, there are 16 candidates, so over
16 candidates in them.
after 16, no test in Jharkhand.
No test has
So
been.
nobody eligible if 7 years is there.
Yes, so therefore, my lord, if there is nobody eligible from Jharkhand, but people from Jharkhand are eligible with other tests. They are being permitted an opportunity for these many number of seats, my lord, which they want
But
to.
do you say 7-year clause is not there in Jharkhand now?
No, I'm saying 7 validity of one TET qualification. My lord, the
Yes,
TET,
please.
the validity of TET exam which you possess, the certificate is for
That is
7
not
years.
relevant for us.
No,
Please go ahead.
it was 7 years is only for that.
No, no, leave aside.
Every state it was 7
Look
years,
into
now it is one,
Whether
We'll look
this
into
is,
here.
this is provided in NCT guidelines, 7 years?
7 years is provided.
From where it
in
came?
The state guide, it
This,
is
this has some object to be achieved.
7.
It's not that simple that you
Please
do away
specify
with
it
this.
in.
No,
I have read over somewhere,
It
it
is
is
now
there.
for life, not one type test is.
It is
you are
there in
not required-
NCT somewhere.
You are not required to get that test again. If I have
Then
qualified,
this becomes a qualification.
my lord, it's only an eligibility. my lord.
Then your double-edged
Eligibility.
argument.
Eligibility.
You see the pattern of teaching and all that changes with time.
Yes, my lord.
So if you say this is only a test for eligibility, then it has to have some life.
My lord,
It's not like BA you have passed, all right, finish.
No, my lord, if it is for life, if it is for life, it is only an eligibility with utmost respect. my lord.
Eligibility is
Because
important.
if, my lord, if, it-
Teachers training test,
my lord, if I pass today,
eligibility.
no, my lord, supposing my lord, I am responding. If I pass it today and I am not for my life now required to take that test again for any recruitment process in future, then my lord, in my humble submission, it would be only a eligibility test, because if with the development in the educational strategies and my lord, the model, if somebody has to get equipped and tested, then my lord, this would have a limited my lord, permissibility to remain in operation. And my lord, your lordship know, now there are requirement that you continuing training programs even after you acquire.
That is all.
Mr. Singh, please finish it.
Yes.
We want to finish this case today.
Two
We
paragraphs,
will not give further time
two
for.
paragraphs, my lord.
It is
only.
enough today.
I am reading last.
Finish it.
Kindly come to the middle of para, my lord, 34. No, my lord, para, all right, skip the last 5 lines in para 34. Merely because the appellants were called for certificate verification, it cannot be contended that they have acquired a legal right to hold the post. Impugned GO 25 did not take away the rights of the appellant from being considered on their own merits.
All right.
As pointed out by
All right, we'll consider.
Next
Next.
35, my lord.
All right, next.
And last, my lord, last submission
Yes.
is that if the date stood extended to April and the amendment has been carried out before that, the state would.
Then applying this judgment, we should.
And
Now understand.
I'll give a, my lord,
Understand your argument.
give a small list of judgments, my lord, where
We'll understand your argument.
it has been held, my lord, that the last date would be the extended date in any selection process. That's my respectful submission.
Thank you. Thank you. Please.
Yes, my lord. Great.
Yes, Mr. Krishnamurthy. What you want to add at this stage?
3 things, Manoj. The drift of the discussion, therefore, is gravitating towards 2 important things, Manoj. What is looming in front of all these discussions is the stipulation in the 2022 rules that the minimum qualification would include ABCD and JTET. That's one. Whether any decision taken by the state, more
But
so,
not included in JTEC, in minimum qualification.
no, that's the argument. I'm saying this is what is the
Not an
primary.
argument.
No,
An argument is qualification,
that's right, Manoj, in the 22 rules.
education and passing of a test.
Correct, Manoj.
All right.
Education, A, B, C, D, A or B or
Yes.
C.
So
plus
it is a
this.
part of the qualification.
That's one. That's one argument, Manoj. Therefore, 22 rules stipulates this. JTET as part of the qualification. Therefore, how can that be done away with, or whether the High Court order is justifiable? The second point, my lords, is the advertisement had been issued already in July of 2023. And that stipulated that the date on which the application is filed, the qualifications had on that date will be the reckoning date. These 2, my lords, are really looming in front of us in terms of arguments. A third argument, my lords, I'm having to go into it for one reason. It was argued upfront by the petitioner saying that 23 of the RTE Act enables only the central government to grant a relaxation. And therefore, it will not be open to the state to make a concession before the High Court and say that instead of JTET, I'll also go in for CTET and TET of any other state, any other neighboring state. Now, 2 things first to be noted, my lords. When the state says that it will look at CTET and TET of other states, it is not, my lords, displacing JTET. That's the first point I want to make. The state, therefore, by saying that it will take note of and take into consideration also candidates who have CTET and TET of other states, is not doing away with JTET. That's a very important point, my lords, to be
You are
noted.
increasing the area of competition.
I bowed on, my lords. That's one. Second point I'm making for my lord's consideration is this. A person who is found in the select list does not have an indivisible right. Constitution bench onwards, number of judgments are
Not
there.
the issue.
That's not the issue. I quite see that. No, that's only the platform on which I want to make my submission now.
No, it is not required to be made to that platform.
Okay.
The reason thereof is we are hinging only on the point that what can be educational qualification prescribed under the rules, something
Yes,
is not there.
Yes.
For the purpose of one qualification,
right.
then for that qualification inclusion is there during pendency of that
Of the process, yes.
process.
Yes,
Then in that situation, what ought to be the qualification acceptable, whether
Correct, correct.
that may be accepted or not,
yeah, correct. No,
which is came later,
I
under
understand.
the judgment of the court.
That's correct. Based on the judgment. of-
Don't go to that consideration.
No, there I was saying that for only one reason. I'm not going to labor on that point.
We
I'm-
have understand the point, expanding the,
Correct. In continuation of that, I'm making this submission. In continuation of the first point, what I'm submitting is this. When the status of such persons is what it is in law, can they come to court and say that the state was not justified in expanding the ambit of persons who can participate? That's the limited submission for my lord's consideration.
make.
Therefore, my submission is, when what you have in law is that limited window of a right to be considered, can you then premise your claim saying that only I have a right to be considered, it is not open to the state to expand?
They are saying as per the rules, they are the only eligible. You
That's
can't
correct.
add ineligible people there.
That's correct. That's what they seem to be saying.
That's the only thing.
That's for which now the second answer.
Yes.
So first is, my lords, the expansion I'm saying, and there is only an inclusion, not any displacement. That's the primary argument. Second submission, my lords. The entirety of this case is there, this argument of theirs is premised on the basis that JTET is superior to CTET or any other TET.
This is not an argument of anybody.
No, I'm saying, my lord, that's the presumption. That's
No presumption.
the unsaid premise, my lord.
Not at all an argument.
I'll tell you what, no, my lord, I'll tell you what, why, how it is coming.
The case of JTET can be replaced by CTET or
No,
other state.
I'll make myself clear on that, my lords. The argument is this. They say JTET is the only one where the peculiar regional requirements of the state are being met.
That is a different argument.
No, in fact,
This
therefore,
cannot be, no.
with great respect, my lords, I'll rephrase myself.
This is
on
not
that.
a question.
No.
This is not a question.
I'm rephrasing myself on that, my lord.
Not a question for us.
No, I'm saying the argument when they say JTET has its uniqueness because that caters to the regional peculiar requirements of the
They are
state.
not saying this. They are justifying
Yes,
why JTET.
yes.
What is the importance of the JTET?
Correct, that's what I'm saying.
This is emphasizing only this much. They
Correct.
are not saying anything.
No,
That is
Can I
superior and anything.
can I just further on my submission on that, my lord? I'm rephrasing myself. So they say JTET with its unique features is such that it was designed in such a manner that the regional requirements of the state are met only by a person who has gone through JTET. That's really the burden of the song. Now, what really has been missed is this. That position of saying choose between one regional language or language of the district, that regime has been replaced. Now the regime is you choose any one of the 15 languages and take your examination in JTET itself. Now,
That's a
Please
different
don't
thing.
respond. This is not at all an argument. This is not at all your stand. You have to please address on the point. Please, coming, as I put to Mr. Maninder Singh also,
yes,
what were your defense before the High Court in first?
yes, I'll say
second,
that, my lord. I'll say
And
that.
after taking of that, what you can do,
Yes,
and in that situation, in these facts, whether whatever you have done is justified. You please answer one question, but nothing is, why you are expanding unnecessarily questions.
no, just,
So many questions are there.
no, one more minute on that point, my lord. I'll tell you, for a
Please
reason.
come on the point. We will finish
Yeah,
today. We are,
No, I understand,
we all have half an hour
Correct,
maximum.
correct.
We don't have more than this.
No, I'm playing a
We
T20.
have
my lord.
already
I'll-
heard you enough. Now,
I'll finish that. Now, therefore, now that regime has changed by which, my lords, there is no longer, my lords, any district preference in terms of languages. That's very important, my lords. And the rules have been amended in such a manner.
It's a district cadre.
I said, correct, district order, but there again, the list that is made is the entire state.
That may be there, but you need to have qualification or TET, JTET for that district only or not?
No, my lord, that's what I'm trying to
What
say.
is the use of this?
Amended.
This is
No,
all-
that, no,
That
that,
we have amended.
correct, it's been amended by,
We have understand.
that's been amended much earlier, before all this. It's been amended, the petitioners have filed it. Just make a note of that page number, I'm done with that, my lord. Page number 200 this is an application for additional documents by the petitioner.
200?
Give me the page number, exact page number. It's annexure P14, my lords, to the,
Page number.
it's the second application for additional documents.
Oh.
I'm so sorry, you do have the number.
Nothing
They are
comes
marked-
in the, nothing comes in the original paper book. Everything comes with the additional document only.
Sorry, my lords.
This is the SOP.
That's true, my lord. I'm so sorry. No, it is marked as P14, my lord.
Just, yes, P14, yes.
P14.
Yes, please.
P14, now this is, my lords, for the, they say this rule may be called the Jharkhand Staff Selection Commission Examination Graduate Level. Conduct Amendment Rules 2023. So this is relating to clause 6 to 8, that is upper primary. Same rule, my lords, has been made for 1 to 5 also.
What is this? These are different rules?
No, these are rules for taking the examination for graduates who will be recruited for 6 to 8. Now we are concerned with what, class 1 to 8, my lords.
This is a different thing altogether.
No, it's entirely applicable to us. This is, my lords, graduates who will take the examination for recruitment for primary.
This is not the issue.
Please.
No, it is, my lords, it is that
Please.
notification.
Please.
Yes.
What are the rules?
The rules, my lords, are the Staff Selection Commission examination rule.
No, you come the rules.
Teachers recruitment rules, we have
Teachers
to see
recruitment
that,
rules.
not this.
No,
This is not the issue here.
no, my lords,
Not the issue here.
no, this is the examination
Don't
rules.
sidetrack.
No, the examination rules,
Please,
not what
please.
the examination.
What are you saying? Examination
Please.
rules are provided in the recruitment rules only, whatever is there.
No, therefore, this is an amendment.
This is not there.
No.
Just, this is,
Staff
that's why
selection-
petitioners have filed it, my lords. That's
They may have filed it, they may have filed,
This is,
they have filed lot of documents, not referred to.
Let us
No, no,
understand.
this-
Please,
yes,
Mr. Krishnamurti. Is it your stand
yes.
either before the High Court or before this court? Please show.
No, before the High Court.
Don't
definitely
make the
not.
submission then.
Yeah.
More than that, please don't make. We
No,
are not allowing.
Please make a.
We are not allowing anything.
This is not relevant.
Not relevant at all for.
Very well, my lords. Then, now please come to, my lords, the issue with regard to the minimum qualifications. Where they say JTET is the qualification which is provided. Now, in that, I am respectfully submitting, the moment there is an amendment to the rules as made in January of 2024, by which, my lords, they say that even CTET or TET of another state will be permitted to participate, will be a minimum qualification. I respectfully submit, my lords, this argument saying that the rules do not provide for it is an argument which goes.
It is not like this. Only argument is,
Yes,
and you have to address only this point.
yes,
They say the date of issuance of the advertisement,
yes,
whatever the rule of the game in force were,
yes,
that will remain in force.
yes,
It will not change.
Yes.
Please make this argument.
yes. Now, for that, my answer is twofold, my lords.
Dislodge this, nothing more.
Yes, for which my answer is twofold, my lords. One, when, my lords, the advertisement was made, there was already a writ petition pending, which culminated in the impugned order. That's one. That's the first point, my lords. So to that extent, it was necessary for the state to take note of the decision of the High Court. That's the first.
State should have waited then.
No,
State
there-
knew that the writ petition is pending.
no, there what
Issues
happened?
are being raised.
No, there, my lords, what happened is this.
First reply you file after
I
the,
bowed down, my lords. My lords are right.
then
My lords are right. But there, my lords, the fact that we filed 2 counters, in my respectful submission, will not take away from the fact that there was a writ which was pending. Added to that, there were at least 3 other proceedings where extensions of time took place based on interim orders of court or otherwise extension of date. Ultimately, my lords, the last one of them was given by my friend, Mr. Maninder Singh.
by interim order, the court said you extend it.
Any
No,
other
the court
point?
stayed the entire process.
Mr. Gurumurthy, Krishnamurthy, any other point?
No, there are 2 other points I have to.
Please, fast.
No, I'll complete it. It's a T20, as I said, my lords, we are playing. There are 2 other things, my lords. Therefore,
It doesn't mean that we are against you.
no, I understand.
Our understanding is.
It's always good, my lords, ask these questions to us so that we are able to fine tune ourselves. Yeah.
Yes,
Now, therefore, this was a process where from June, July, this had started. The advertisement had come. I am alive to the fact that I had filed two affidavits before the High Court, but notwithstanding that, the intervening circumstances were such that including a court proceeding where there was a stay, there was extension of dates.
No.
And the
Where was the stay?
a stay was
Stay
one connected repetition.
What was the stay?
Now that was, give me the order. Process was stayed. There's an order.
Let us see.
Give me the order. I'm so sorry.
Waiting for para teachers.
No, my lord, I'm saying the process was stayed. The
There is-
process was stayed. Same process, same advertisement. I don't understand how they can even raise this objection.
The advertisement is the same.
Yeah, advertisement is same.
Process of recruitment and date and all that, it was.
Please see the
Same,
second
ma'am.
page, my lord. Second page.
Ma'am, it is same.
Here.
Whereby the appointment of Sahayak Acharya has been published, so and so shall remain straight. Please make the word.
This is one, my lord. This is one. There are two other things, my lord. There are two other things I have to highlight.
No, but Mr. Krishnamurthy, this the state level working committee has recommended BRC and CRC 50% reservation of Sahayak Acharya.
Yes.
So it appears that this is advertisement 13,
Same thing, my lord.
1323.
Yes.
Take to Sahayak Acharya.
No, but the process is stayed, my lord. Same advertisement.
Acharya only.
No, but the entire
Kindly.
notification.
Last
Committee
three
whereby
times.
the appointment of Sahayak Acharya has been published so and so by the staff selection commission, so and so shall remain
My lord,
state.
Sahayak Acharya is assistant teacher, my lord.
Sorry.
It's a assistant teacher. Sahayak Acharya means assistant teacher.
Was vacated.
No, please, have you given that? There's a second order given, my lord. Is it there, my lord? I'm sorry. That's dated. Just give me that.
This is 5-9 only.
5-9 and then 5-10, my lord. The order is vacating it 5-10.
5-10.
My lord, give one more copy, please.
Subject
You
to
have
final
given
outcome.
number of,
There's another, this is the order vacating it. This is one, my lord. Then two other things, irrelevant developments. My friend placed those notifications of January, February and March, my lord, by which the extension took place, including the amendment.
That we have understood.
Yeah, then prior to that, in my lord's October, there is another notification issue, extending the date, and one in December.
we don't know, there is nothing on record, is
No,
playing the
I
cards
understand.
only one by one, like somebody is playing cards like this.
I understand, my lord.
Is
This
this
is
the
not-
way the cases are argued?
No, I understand, my lords. This-
Nothing before the High Court, everything before this court?
No.
And here also card to the chest.
No. I
One
understand.
by one it is coming.
No, I understand, my lord.
Strange thing here we have seen.
No, this is something we.
And from state has to behave fairly.
No, I follow, my lord. I quite understand, but this is the factual position. my lords. I'm
Actual
not-
position?
Again,
Is this the way?
Mr. Guru Krishnamurthy, what
Yeah.
is the problem?
No, I,
Two counsels appearing, senior counsels.
This question is coming. Question is coming when the counter is filed here in this case.
when was it filed? When did you file it?
Everything happened 1 year before that.
True, it's true. Very true.
All right, this counter affidavit has been filed
Yes,
somewhere in 5th of April 2024.
true.
Once it is filed in 5th of April 24, all this material was with you. Why
Should
you
have
have
been.
not placed before?
I'm not defending that.
And at that time, you must have clarified, we can understand in a counter before the Supreme Court.
I
Our
quite-
stand in the first counter was this. Second counter was this. Because of this judgment, this amendment have been brought. Now we are supporting this amendment for these reasons.
Correct.
If we see this counter, if we see in all these things, nothing is in the counter like this.
No, I understand.
It is everything just to surprise throwing.
We
He'll
were
not
taken
say-
by surprise yesterday evening by getting all this material. my lord.
Good
All
enough,
right,
good enough.
let us,
Thank the state
us-
for the,
No, just,
state is in safe
let
hands
us
if they are
close this
behaving like
surprise
this.
today.
no, just two more
Let
things.
us close this surprise today.
No, two more things.
Yes, two more.
Two more things. One, section 20.
Any more surprise?
No, my lords. No, therefore, just to complete that loop, my lords, I'm respectfully submitting therefore, this is not the case where, my lords, there is a change in the rules of the game when the process has been initiated. In fact, the process itself got delayed from time to time. Ultimately,
you
the
want
exam-
There
to
is
convey-
nothing on record.
You want to convey this,
Yes,
rules were already there. When there was a litigation in the court and there was an order, so we have changed the rules of the game. All right, and accordingly, we have changed the process.
no, in fact,
So say like this.
it's not something.
I think in a nutshell, we can say one line, that is the enough.
No, just.
So accordingly, we have done, and now, because we have done this, by this change as per the judgment of the High Court, so please acknowledge this is the right approach of this thing.
No, I'm saying
Say this-
there are reasons for this. And my lords, there is basis for this for the reason that guidelines 10 gives that leeway to the state. I pointed out right at the beginning, my lords, I'm increasing my zone of consideration of people. That's the primary argument, my lords. Second, my
That
lords,
argument we have understood. We have had him put any question to you,
no, I understand.
not put any question.
I bow down.
All right,
I bow down.
that is all.
Very good. Then one last thing. 23 of the Act. Much emphasis was laid on 23 of the Act. Let me proceed on the basis for the time being, my lords, on the basis that TET is a qualification. And it is some kind of a qualification for the purpose of 23(2). I'll proceed on that assumption. In my respectful submission, it is not so, but still I'll proceed on that basis.
This is in
20
our mind. This is in our mind.
No, I understand. I understand.
Whether it is a qualification is TET,
Yes,
CTET,
yes,
MPTET,
yes,
Jharkhand TET, Bihar TET,
yes,
but TET is a qualification.
yes.
Now, and in that situation, once this qualification have been prescribed, then looking to this situation, we have to look into this qualification, then connecting rules. All right, and accordingly, we have to proceed in the matter. But suppose that is a qualification prescribed, then in that situation, the domain of the state which is given under this policy of NCTE
Yes.
can be taken away, or can some judgment may be like this, by way of 23 can be done away? Our answer, probably what we are thinking at present is subject to dislodging. It cannot be.
I follow, my lords.
But
Yes,
for that purpose,
yes.
you have to specify and follow a procedure as specified there. So that
I
is,
follow, Manoj.
if we see your entire since beginning and everything, your intent was not like that, you want to give this benefit. So here the everything is lying.
No, I
This is
follow,
answer
Manoj.
of this, here the question, here the problem.
No, I follow, my lords. What my lords are telling me is this.
And
Manoj, I
Maninder-
understand. The
Maninder
drift
thing
of the
is-
stand of the
Maninder thing
state.
knows everything.
No,
He knows very intelligently.
no, no,
He
shall I-
deviated from one line to the second line to third line.
the drift of the stand was saying that these people cannot claim, and thereafter, my lords, the stand has been taken, is what is my lords are pointing out. I understand. I'm on something which is in respect of a legal issue. I understand what has fallen from my lords. No, 23.
How much time, please?
No, another,
Otherwise,
I'm done with this point.
We will finish today.
Yes, I'll finish.
We will not
and then
admit-
we'll submit.
We will finish today.
Yes,
We
just,
will not give more time.
just a few more minutes on this, my lord. Just a few minutes. No, just, please see this formulation.
State is with you only.
State is defending you.
In double barrel gun with state.
Now, my lords, it's like this. 23-2.
All barrel gun with woman empowerment.
Now, it's like this, my lords. Now, 23 is for a certain time period. That's the first point, my lords. 23-2 is for 5 years from the date of the commencement of the act. That's one. For a specific purpose. That's the first point to be noted, my lords. Please have a look at 23. Now, please see.
We have seen this.
Yeah, my lords have seen
That
that.
has been prescribed
Yes,
that up to a period of 5 years.
5 years. one more thing, my lords. Please come to the rules. Rules 17 and 18.
17 and 18. Yes, please.
Now, if you see 17, my lords, the minimum qualifications are set out as per the academic authority. That is under the act itself, my lords. It's there in the Bar Act itself. My lords. Now, please come to 18. Now, 18 also, if my lords will see, it is with reference to time. First is 18.1. It talks about how within 6 months from the commencement of the act, estimate the teacher requirement as per the norms. Then second, where a state government or union territory does not have adequate institutions. Now, 18.2 is almost a verbatim reproduction of 23.2 in terms of language. Of training on teacher education of persons possessing minimum qualifications notified in sub-rule 2 of 17 are not available in sufficient numbers in relation to the requirement of teachers estimated in sub-rule 1 shall request within 1 year of the commencement of the act, again with reference to time, the central government for relaxation of the prescribed minimum qualification. Then on receipt of the request referred to in sub-rule 2, the central government shall examine the request of the state government or the union territory and may by notification relax the minimum qualifications. Therefore, this is something, my lords, which entirely is with reference to time. That is one.
Wrong.
I'm so sorry.
Read.
Uh,
That 5 years is from the date the central government will issue the notification.
That's correct. Now, to 2010, it has come, my lords.
Not for
2010, the NCT was appointed. 23/8/2010, they made, my lords, the minimum qualification. 11, they made the guidelines, my lords. So, all
The central government may, if it deems necessary, by notification, relax the minimum qualification. That means the date of relaxation
correct, my lord.
from the required for appointment of teachers, not exceeding 5 years,
Correct.
from as may be specified in that notification.
No,
So it is the date of relaxation,
correct.
notification of that 5 years.
But
Not
all
that the 5 years end with the 2009 Act, so 14 this provision goes.
No, my lord. No, I'm so sorry. I'll make myself clear on that. All this is traceable to 23. 23 talks about 5 years from the date of the act. That's important, my lord. 23.2. Please have a look at that.
Not 23.2 only I was reading.
No, just have a look
Read,
at that.
read,
my lords.
read.
Please say, my lords, I think we're reading from
23.2 only.
4, my lords. I think my lords read from 4.
No, 23.2.
Just see that again, my lords, for a minute.
Third line, the central government may, if it deems necessary, by notification, relax the minimum qualification required for the appointment of a
period
teacher
not exceeding 5 years as may be specified in the.
for such period,
No, please see
not
the
exceeding
proviso.
5 years from, as may be specified in that.
You see the
notification.
provisos also, my lords.
Yes.
See the provisos provided further that a teacher who at the commencement of this act does not possess minimum qualifications.
So he has to acquire it in 5 years. That
Therefore, my lords, therefore, the main provision read with the provisos will mean there's a cutoff of 5 years. From that act, you have to acquire the qualification.
that's a different thing.
They have to acquire. Therefore, this
That's a
relaxation.
different thing. That doesn't make the ineligible eligible.
No, therefore, I'm saying, my lords, this relaxation also must be for.
Nothing.
One last thing, my lords, one
Let's
last.
see the concept, please.
One more,
Not like this.
one more thing.
Brother is
Then I'm done.
absolutely right on that point. You kindly see.
Yes.
The central government may,
Yes,
if it deems necessary,
yes, yes.
by notification, relax the minimum qualification required for appointment of a
Correct.
teacher
Correct, my
for
lord.
such period,
Yes,
not exceeding 5 years,
yes.
as may be specified.
In that notification.
In that notification.
What fell from my lords, yes.
So that is fine. Whenever the notification, you follow the procedure. Notification could be issued by the central
This
government.
has to be read with two provisos, my lords. That's my submission.
Proviso is altogether different.
Proviso, let us understand.
That's when the act was
Proviso-
enacted.
Proviso can take a substantive character of the act. No,
You can't.
it either explain or curtail.
Or, correct, or take an exception, my lord. It becomes an exception to
think-
the main provision.
Cannot be taken substantive
Therefore, I'm
character of the
saying-
act or provision of the act.
There is one last thing I'll say, my lords. One last. I'm saying, my lords, TET at the end of the day is an eligibility test. I respectfully submit, my lords, it's not an academic qualification.
That has been argued.
That's right.
Yeah.
That I adopt, my lords. I
Anything
therefore
else?
submit, my lords.
Fine,
I'm
all right, yes, ma'am.
Given the time, I do not know whether I'll be able to conclude, but I'll start nevertheless.
Let us understand what is your point of argument.
Yes, my lords. My lords, first of all, I must point out, my lords put a question to my learned colleagues heretofore. While I'll answer that question in my way, but the fact that the argument that is advanced before my lords, that the rules of the game have been changed once the game has begun, namely that after the advertisement, the qualifying.
No, this is not an argument. Argument of their part is advertisement was issued pursuant to the rules.
Yeah.
On the date of the advertisement, whatever the rules in vogue, that cannot be changed.
That cannot.
That is there.
So they said
So
it
in
cannot. be-
place of, otherwise, we are thinking.
Subsequently, it cannot be changed subsequently after the advertisement. That is the case. Now, my lords, this ground is nowhere emerging at all anywhere in the SLP. So therefore, for anyone to have addressed that in a reply or put those documents there, my lords, it will be testing us to a point that we can answer only what is being urged there. Having said that, but I will nevertheless make an endeavor to satisfy my lords. My lords, my first submission that I make to my lords is that the authority under the central government, which is going to fix the minimum qualification envisaged under section 23 for purpose of appointment of teachers, whether it's to the primary or to the secondary school, is the NCTE. NCTE lays down that minimum qualification. It may be open for the states to have higher, it may be open to have lower. It is also
No,
open.
not
to-
lower.
Not low.
My lords, not
Commission.
lower than, not lower than what NCTE?
Yes,
Absolutely, I bow down.
minimum
I was-
standards.
I was on the mind with CTET. I was in the mind with CTET. I bow down. I was wrong. I stand corrected. My lords are right. So, my lords, the states are required to conduct, they may conduct their own TET exam. But in the event they do not conduct their own TET exam, the 2010 notification makes a provision. However, TET is like an essential prerequisite for the purpose of a state considering the candidate both on the qualification, which is the B.Ed or the D.Led, or as the case may be, what my learned friend showed, plus the TET before any candidate can be considered for purpose of appointment to the post of a teacher. Now, my lords, in the 2010, I will only request you for a moment to read with me page 226 and 227. I'm going to be very, my lords, fast, and I'll try to do it as swiftly as possible, I assure you. But so, my lords, this is the NCTE. This is the 2010. It has been read, but I read it with a small difference. And my lords were right when my lords said that my lords have read somewhere in NCTE that there is a period of validity. Undoubtedly, it is here at page 227. TET conducted, one is by the central government, will apply to all schools referred to in subclause 1-2, which is the central government schools, my lords. I'm not going to change that position. TET conducted by a state government or a UT will apply to schools of a state government or a UT. So, my lords, state governments or UT, their TET which is conducted will apply to them. My lords, please come to the one below. That is what I'm concerned with. A school at 1 and 2, which is under B, which is the state or the UT school, may also consider eligibility of a candidate who has obtained TET certificate awarded by another state UT with legislature. In case the state government UT with legislature, so first sentence is, my law said it can consider. It's not that it is, the state is completely barred from taking into consideration a TET qualification a candidate may have acquired from another state or from the CTET. Next sentence, my lords, and a separate sentence. In case, now what happens where a case the state does not conduct? In case a state government decides not to conduct TET, a school at 1 and 2 in the state UT would consider. First of all, it may consider them. Number 2, if you don't conduct the exam, you would
They
consider.
decide not to conduct.
My lords, I agree. If
The
you,
decision by the state.
but the first.
It's not that simply non-conduct of exam.
My lords, I read the two separately. I read the
Separate,
first
these are
sentence separately and I read the second sentence
Yes, yes,
separately.
yes.
The first sentence is, it may consider. And the second sentence is, if they decide not to conduct the exam, then, my lords, they can take both the. So, my lords, what I'm trying to say is, the minimum eligibility criteria of TET being one of the prerequisites for purpose of appointment as a teacher, the qualification does not go away. The test does not go away. The requirement is there to have that TET, but you can consider the TET from that conducted by CTET, which is the central government, or that of any other state. The state can do that. My lords, I know my lords have a question on the advertisement. Allow me, give me a moment. I'll try and answer that to the best of my ability. Would my lords now turn over the page? And my lords were absolutely correct when my lords mentioned that my lords had a recollection on a validity, and it's a very important facet. Today, maybe the NCTE and the state has said that it is valid for your life, but there is a very big importance, and I'll make good that why it is important. Appropriate government should conduct TET at least once every year, should. The validity period of TET qualifying certificate for appointment will be decided by appropriate government subject to maximum of 7 years for all categories. But there will be no restriction on number of attempts a person can take for acquiring TET certificate. A person who has qualified TET may also appear again for improving his or her score. So, my lords, continuing improvement, changing, etc., is a something that NCTE recognizes and suggests. Maybe perhaps today they have said that it is possible you can have the qualification for life to have an appointment as well.
Where is that?
My lords, I am informed by my colleague that subsequently, even in Jharkhand,
No, not Jharkhand, because they say maximum is 7.
it is dated now.
This-
9/6/2011, 2021.
How can they do it? This is maximum is 7.
Extension of validity period of teachers' eligibility, NCT has done.
NCT.
So, my lords, therefore, I can't quarrel with that. They are the appropriate.
NCT has done it then.
Right. Now, my lords, I come down to validity. Whether the state could have considered or not. My lords, how the state did is not for an area for me to enter into. But could the state have done that is something that I want to satisfy my lords.
Madam, how much time you will take?
My lords, I would at least have requested my lords for half an hour, but I leave it in my lord's hands. Please give me that.
We'll continue by tomorrow for half an hour to you,
Please.
15 minutes to you.
Very good. I'm so glad then.
Tomorrow morning, we'll continue this because it will not unnecessarily go. There
My
is no
lords,
purpose.
my
We
lords, I
don't want to
request-
curtail your point.
I'm
Correct?
much obliged.
Right, but you at least today our request is. Mr. Maninder Singh will offer you a cup of coffee for today.
My lords, I will make sure to demand that one.
Yes, that is our saying only. Nothing more. Mr. Singh,
Double, my lord.
double, fine, thank you.
Patiala.
Patiala.
Double short copy.
My lord, I'll rest with.
Later in the evening offer is also.
I always.
One thing we are further requesting, your note of submissions, you have submitted both your note of submissions by tomorrow. By tomorrow, we want, madam, your also,
My lords, I'll
so let it be finished by
I
tomorrow.
will put it on.
And that, we are asking a CTET rules,
In fact, what I have in the morning, we will information monitoring.
you take it back. These only the rules,
It's inside, I did it for the.
all right. All right, we want this CTET. Keep it. You give it tomorrow. If any amendment is there, add it. After hearing, you give it, you also give back to Mr. Gopal Satyanarayan. You take it back and you add it, whatever you want to do. Compare with that and that. Add it. ये इसमें रख दीजिए, उसमें रखा हुआ है। मेरी फाइल मेरे यहीं पहुंचेगी, मुझसे नहीं पहुंचेगी। We'll take it tomorrow, immediate after this motion. If 1, 2, 3 is there, we will take this case.
Grateful.
कल के लिए करते हैं, hearing continue for tomorrow.
maybe the NCTE and the state has said that it is valid for your life, but there is a very big importance, and I'll make good that why it is important. Appropriate government should conduct TET at least once every year, should. The validity period of TET qualifying certificate for appointment will be decided by appropriate government subject to maximum of 7 years for all categories. But there will be no restriction on number of attempts a person can take for acquiring TET certificate. A person who has qualified TET may also appear again for improving his or her score. So, my lords, continuing improvement, changing, etc., is a something that NCTE recognizes and suggests. Maybe perhaps today they have said that it is possible you can have the qualification for life to have an appointment as well.
Where is that?
My lords, I am informed by my colleague that subsequently, even in Jharkhand,
No, not Jharkhand, because they say the maximum is 7.
it is dated now.
This-
9/6/2011, 2021.
How can they do it? This is maximum is 7.
Extension of validity period of teachers' eligibility, NCTE has done.
NCT.
So, my lords, therefore, I can't quarrel with that. They are the appropriate.
NCT has done it then.
Right. Now, my lords, I come down to validity. Whether the state could have considered or not. My lords, how the state did is not for an area for me to enter into. But could the state have done that is something that I want to satisfy my lords.
Madam, how much time you will take?
My lords, I would at least have requested my lords for half an hour, but I leave it in my lord's hands. Please give me that.
We will continue by tomorrow for half an hour to you, and 15 minutes to you.
Very good. I'm so confident with that.
Tomorrow morning, we'll continue this, because it will not unnecessarily go, there
My
is no
lords,
purpose.
my
We
lords,
don't want to curtail your point.
I'm
Correct?
much obliged.
Right, but you at least, today our request is, Mr. Maninder Singh will offer you a cup of coffee for today.
My lords, I will make sure to demand that one.
Yes, that is our saying only. Nothing more. Mr. Singh,
Double, my lord.
double, fine, thank you.
Patiala.
Patiala.
Double short coffee.
My lord, I'll rest with.
Later in the evening offer is also.
Uh,
I always.
One thing we are